Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2 of Jefferson County, Texas. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to County Court at Law number 2 today for an arraignment. What the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your options are, and what your rights are concerning your case. The case that you have in County Court at Law number 2 is a misdemeanor case. Criminal cases are divided into either felonies or misdemeanors. Your felony cases are normally referred to as your more serious type offenses. Now, your misdemeanor cases are normally referred to as petty offenses. Now, it doesn't mean that they're not serious. They're just not as serious as the felony offenses. And when I'm talking about serious, I'm talking about not only the offense itself, but also the range of punishment. That is what your punishment can be if you are convicted of a felony or misdemeanor offense. Now, if you are convicted of a felony offense, the felony offenses are divided into 5 categories. The highest felony is a capital murder, and the range of punishment for a capital murder is life or death. Below that is the first-degree felony. The range of punishment for a first-degree felony is 5 to 99 years in the state penitentiary or life. Below the first-degree felony is a second-degree felony. The range of punishment for a second-degree felony is 2 to 20 years and a fine up to $10,000. For a third-degree felony, the range of punishment is 2 to 10 years and a fine up to $10,000. And for the lowest felony is a state jail felony, and the range of punishment for a state jail felony is 6 months to 2 years in the state jail, a fine up to $10,000. Now, for your misdemeanor cases, misdemeanors are divided into 3 categories. And the highest misdemeanor is a Class A misdemeanor, and below that is a Class B misdemeanor, and the lowest misdemeanor is a Class C misdemeanor. Now, your Class C misdemeanors are cases that are normally filed in either the Justice of Peace Court, which is the JP Court, or the Municipal Court, which is the City Court. And the range of punishment for a Class C misdemeanor is fine only. So you cannot be given jail time. You only could be given a fine. For example, a speeding ticket is a Class C misdemeanor, or if you're not wearing a seatbelt, that's a Class C misdemeanor. And there are a whole host of other Class C misdemeanors. But the main thing is that the range of punishment for a Class C misdemeanor only entails a fine only, not jail time. Now, right above the Class C misdemeanor is a Class B misdemeanor. Now, for the Class B misdemeanor, the range of punishment is 0 days to 180 days, which is 6 months in the county jail or anywhere in between, a fine from $0 to $2,000 or anywhere in between, or you could be given both such fine and confinement. Then you have the Class A misdemeanor, which is the highest misdemeanor. The range of punishment for a Class A misdemeanor is 0 days to 365 days in the county jail, which is 1 year, or anywhere in between, a fine from $0 to $4,000 or anywhere in between, or you could be given both such fine and confinement. Now, your Class C misdemeanors are cases, as I said, that are normally filed in the JP Court or the City Court. They come to this court, County Court at Law number 2, when they are appealed. For example, if a person is convicted in a municipal court or the JP Court and they want to appeal that case, and then that case comes here. And so once it comes here, the range of punishment does not change. It's still fine only. Now, as a defendant in a criminal case, as I said earlier, you have rights. And the paperwork that you have in your hand refers to your right to have an attorney. The first document is titled Judge's explanation of rights to defendants without attorney. And it reads, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor. Now, the prosecutor is the assistant district attorney who's handling the case. He works for the DA's office. Now, you may not speak to the prosecutor about your case unless you sign a written waiver. And what the waiver is, you're saying that you're waiving your right to have an attorney, you want to represent yourself. Now, unless you sign a written waiver of your right to be represented by an attorney. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of the document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If you've already hired an attorney to represent you, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you have already been appointed an attorney in your case, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you'll put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign at the bottom of the document where it says signature, and you will date it today's date, which is June 7th of 2022. Now, for those of you who will be waiving your right to an attorney and desiring to represent yourself, then you will have to read and sign the second document. The second document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, if I have been advised this 7th day of June of 2022 by the County Court at Law Number 2 of my rights to representation by counsel in this case pending against me, I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign on the line that says defendant, and you will date it today's date, June 7th of 2022. Now, you also have other rights. You have a right to have a trial by jury. And when a young lady is sitting in that area over there, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your jury, and they will listen to all of the evidence, and they will decide whether or not you're guilty or innocent after deliberating. You also have a right to waive, which means you have a right to waive or give up your right to have a trial by jury. By waiving your right to have a trial by jury, you will not be having a trial by jury. Now, your case will come before the court, and your case can come before the court. When I say the court, it becomes before the judge in one of three ways. One way is by way of a bench trial. What a bench trial is, it's a trial with a judge only. You don't have a jury, you just have the judge. The judge will listen to evidence, and the judge will decide whether or not you are guilty or innocent. If you are found guilty, then the judge will also assess your punishment. The other way your case will come before the judge is by way of a plea bargain. If for example, if you decided that you want to either enter a plea of guilty or no contest. Now, a person who enters a plea of guilty, what you're saying, you're telling the court that you committed the offense that you've been charged with. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charge. Now, if you enter a plea of not guilty, you're telling the court that you did not commit the offense. Now, if you enter a plea of either guilty or no contest, your case can come before the judge by way of a plea bargain agreement. Now, what a plea bargain agreement is, it's an agreement to settle your case. In essence, you and your attorney, if you're represented by an attorney, or if you're not represented by an attorney, then it would just be you only, will talk to the district attorney. And the district attorney, assistant district attorney, will make an offer to settle the case. If you accept that offer to settle your case, then your case will come before the judge. We call that agreed plea bargain. Now, the judge can do one or two things. He can follow the plea bargain agreement, or he cannot follow the plea bargain agreement. If the judge does not follow your plea bargain agreement, then you can take your plea back. And that's when you can say, well, I'm not pleading guilty, I'm not pleading no contest. If the court does not follow your plea bargain agreement that you've entered into with the state. Now, the other way your case can come before the court is by way of an unagreed plea bargain. What that means is you enter a plea of either guilty or no contest, and you and the state have not reached an agreement, and you want the judge to assess the punishment. So we call that an unagreed plea bargain. So your case, if you waive your right to a trial by jury, your case can come before the judge in three ways. One is by way of a bench trial, that's with judge only, or it could come before him by way of an agreed plea bargain if y'all worked out an agreement with the state or the district attorney, or the other way, if you have an unagreed plea bargain and you have not been able to work out an agreement, and then the judge will decide what the punishment is. Now, you also have a right to have witnesses to come to court. That chair over there that I'm pointing at is called the witness stand. And what witnesses do, they'll come to court, they can testify. They can either testify for you or against you. And if you're represented by an attorney, your attorney can ask them questions, or if you represent yourself, you can ask them questions. We call that either direct examination or cross-examination. Now, you have a right to waive or give up your right to have witnesses. And what I mean by that is you have a right not to have any witnesses come to court if that's your desire. You have a right not to call any witnesses in your case. Now, if you do not call any witnesses, that does not mean that the state will not be calling witnesses. It just means that you will not be calling witnesses. The states will be calling witnesses in the case that they have against you. Now, the other thing is you can waive or give up that right to have witnesses. And if you do that, as I said earlier, you will not be calling any witnesses on your behalf to testify in your case. You also have a right to have discovery. And well, let me back up before I get to that. You also have a right against self-incrimination. We call that the Fifth Amendment right against self-incrimination. I know sometimes you may have heard people say, well, I take the Fifth. And what that means is I'm not going to say anything that's going to incriminate myself. You have a right not to testify against yourself in your case. We call that the Fifth Amendment right against self-incrimination. Now, you have a right to waive or give up that right as well, which means you can decide that you would like to testify in your case by waiving your right or by waiving your Fifth Amendment right against self-incrimination. Now, You also have a right to have discovery. Discovery means you have a right to see the evidence that the state has against you. You have a right to see the documents, videos, witness statements, your statement, objects, whatever the state has that they're going to use as evidence in your case, you have a right to have access to that. Now, if you are represented by an attorney, your attorney will have access to it. If you are representing yourself, you can have access to it. Now, you can waive or give up your right to have discovery as well, which means you have a right. You can say, well, I don't want to have access to the evidence that you have or that the state has against me. Now, everyone here has been arrested on your case, and you're out on bond. You're either out on a cash bond, you're out on a PR bond. PR bond is a personal recognizance bond, or you are out on a surety bond. A surety bond is where you have a bondsman. Now, every day that you were in jail, you can get credit for that jail time toward your sentence. For example, let's say you spent 5 days in jail and before you got out on bond. Now the state is offering you and the state has reached a plea bargain agreement, they are offering 5 days in jail. Then that means that you won't have to do any more time in jail because you already did 5 days in jail. Therefore, you'll be given credit for time served. Now, if they're offering 7 days in jail, you did 5, that means that you have to do 2 days because you already have 5 days credit. They'll take 5 from the 7 and leaves 2. Now, if the state is offering you a fine and court costs, now every day that you spent in jail, it is credited as $100 per day toward your fine and court costs. And what that means is, for example, if the state is offering a fine and court cost of $500, you spend 5 days in jail, 5 days in jail is $500. And so that $500 credit can be used toward your fine and court costs. And so if they're offering $500 plus court costs, they're offering a fine of court costs, you equaling $500, then you won't have to pay anything because 5 days in jail has already paid it off. Therefore, it will be taxed and retired. Now, if they're offering fine and court costs of $700 and you spend 5 days in jail, then you only have to pay $200. Now, let's say you can't pay the $200 on the day that your case is finalized. Then we can put you on a payment plan. In essence, you could pay it off in installments. But let's say, even if you put me on a payment plan, I can't pay it off. Why? Because I don't have the income. No problem. Because the law allows the court to convert your fine and court costs to community service. So if you can get community service and just work it off. Now, the way it works is every hour that you do, you get $12.50 that will go toward your fine and court costs. So if you work 8 hours a day, 8 hours in one day, that's $100, okay? If you work 2 8-hour days, that's $200. So we can convert it to fine and your fine and court costs to community service. Now, Jefferson County has a program that is called pretrial diversion. It's for first-time offenders. And what pretrial diversion is, they will dismiss your case. And if you successfully complete the pretrial diversion, you can get it expunged from your record. Expunged means you can get it erased, deleted, or wiped off of your criminal record. And the way it works, first of all, you have to get an attorney to help you to get into the program. They can fill out the application and send a letter to the DA's office. And the other thing is it has to be your first offense. And the offense cannot be an offense for unlawful carrying a weapon or resisting arrest. If it's any other offense, then you can apply for pretrial diversion. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office also has a program that is called Veterans Court. Veterans Court is part of the pretrial diversion program. And it's the same thing. You get into the program, complete the program, the case is dismissed, you can get it expunged from your record. In order to get into the pretrial, in order to get into Veterans Court, you just have to be, you have to have served in any one of the branches of the United States military. Now, this court, County Court Law Number 2, has a program that is called the Community Safety Initiative. The Community Safety Initiative is a program that I started within the first 100 days of taking office back in March of 2017. With that program, the program is designed to make Jefferson County a safer place by addressing the issue of recidivism. Recidivism meaning people committing crimes over. And how do we address it? Well, we have partnerships with local agencies in our Jefferson County area. We have a partnership with Spindletop. Spindletop is our local mental health center. And with Spindletop, they will be able to do a private interview, do an assessment, and they can develop a treatment plan, either outpatient or inpatient, depending on your needs. Now with Spindletop, the services that we have here available in that program, you do not have to be incompetent to stand trial or insane. You can suffer from anxiety, depression, bipolar, schizophrenia, post-traumatic stress, ADD, ADHD, or any host of other mental illnesses, and they'll be able to address those illnesses, and they'll develop a treatment plan that will help you with whatever mental illness that you may have. Now, if you have an issue, you have a problem with drugs or alcohol, Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. Now, they also, the local Alcohol and Drug Abuse Council has a program that is also called OZAR, stands for Outreach, Screening, and Assessment Referral. And what will happen in both of those programs, they will first of all do a screening, that is an interview. They would do an assessment, and then they would develop a treatment plan, either outpatient or inpatient, to address your drug or alcohol problems. And the other thing is, if you are unemployed, let's say you're unemployed, you're looking for a better job. Well, we have a partnership with the Golden Triangle Empowerment Center, and the Golden Triangle Empowerment Center has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program at Lamar University. It's the program CICE is through Lamar University, and that Golden Triangle Empowerment Center has a partnership with them. Now you will be trained in either the hotel industry, the shipping industry, or the chemical industry. Once you're trained in one of those areas that you select, then they will assist you at getting a job in the area that you're trained at. CICE also has a program for individuals who have not graduated from high school. If you would like to get your GED, your graduate equivalency diploma, they have a program where you can get your GED. Now, all of these programs that I just talked about, the program with Spindletop, the program with ATAR and OZAR, the program with CICE, the job training, job placement program, and the GED program, all of those programs that I just spoke about are free. It does not cost you anything. Only thing you have to do is have a desire to be in the program. The other benefit is all of those programs can be used as community service toward your payment of your fine and court costs. So for example, let's say you are in a job training program or in a GED program, in a drug program, or in a mental health program. Every hour that you do in that program, 1 hour will go as community service, and $12.50 will go toward paying your fine and court costs. So in essence, you're doing one thing, but you're getting credit for three things. You're getting credit for being in the program, you're getting credit for paying your fine and court costs, and you're getting credit for doing your community service. This program, I always tell people this, is that when you come to county court at law number 2, we do not have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before the court. And we're trying to make a difference in in our Jefferson County community by producing productive people. We do not just give time in County Court at Law number 2. We take our time because we believe that we can address the problem instead of just arresting the problem. And so if you're interested in the programs, just let us know. And we have someone that can assist you with getting the information you need to get into either one of those programs. And at this time, we have Ms. Sarah. She is with Spindletop. She's going to come forward and tell you a little something about the program that they have at Spindletop. Sarah?
Thank you. I'm here today on behalf of Spindletop because what the judge has found is that whether it's your first time or your 10th time, the rate of clients in the court has some connection to mental health or alcohol and drug abuse. I'm here today to give you an opportunity to address those problems if that's you or if that is someone else that you know. And at the very least, you'll be given describing what I do and what my coworkers do. And you'll have an opportunity to speak to me privately if you would like to. If you have any concerns, questions about the program or regarding mental health. And I passed out earlier a demographic sheet that is just for my records. It is totally HIPAA compliant, meaning that I cannot share that information. It's just for our records. If you would like more resources, there's an option at the very top of that page to write in if you would like to be contacted for resources. Thank you for your time.
Thank you, Sarah. Now, ladies and gentlemen, we have our court personnel here to assist you with the paperwork that has been handed out to you. What we're going to do is have someone from our court come around, and whatever questions you have, they'll be able to get that information from you. Sir, you had your hand up?
Yeah, just have a quick question. So I'm from Montana, like I work offshore out here. I'm supposed to be, I mean, it took a little bit longer for me to get down here. I got in probably about 2-3 hours ago. I'm meeting my attorney. I should have been meeting him here today. So I mean, I'm just obtaining my attorney and then he's gonna take care of it.
Okay, well, you just need to fill that paperwork out. Okay, what we're gonna do, we're gonna go through the paperwork, and once we go through the paperwork, you'll be put in one of the categories. So at this time, if anybody else need any assistance, we have, as I stated earlier, we have folks in our court that will go over the paperwork with you. So at this time, it's going to take a few minutes to do that. Now, if you need to, there's a restroom outside the door. If you need to go to the restroom, you can do that, but make sure you do not leave the courtroom. Not the courtroom, the courthouse. Because if you leave the courthouse and we're not completed, then your bond may be forfeited. If your bond is forfeited, then that means they'll issue a warrant for your arrest. So at this time, the court will be in recess.